Let's go back to 2011. The level of NPA as a percentage of gross advances began climbing up right from the year 2011 and reached its peak in 2018 at 11.18%. In the year 2016, a watershed year in many respects, banking sector's gross non-performing assets was as high as 7.6% of the total credits. The amount involved a huge 5.5 lakh crores. The situation was scary and alarming, and there wasn't an effective handle to take care of NPA in the banking system. True, there were legislative framework for insolvency and restructuring, but they were fragmented across multiple legislations such as the Companies Act 2013, SICA 1985, that is Sick Industrial Companies Act, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which is called as SERFASI, the Recovery of Debts Due to Banks and Financial Institutions Act 1993 for debt recovery by the banks and financial institutions. There were many. These laws were ineffectual, and your petition in the court for recovery took years to be heard, and even more for a judgment to be pronounced. So the need for the hour was a law which had teeth and delivered swift justice to the lenders, while at the same time unlocking the values of productive assets and its swift deployment. Enter the Insolvency and Bankruptcy Code 2016. Hi, welcome to Think and Link series. I'm your host Srinivasan, and today our conversation will revolve around IBC, the Insolvency and Bankruptcy Code. We will take a 360-degree view of this act, but let's begin with a small intro of this IBC Act. IBC Act was an act which consolidated all existing insolvency-related laws, as well as amending multiple legislations, including the Companies Act 2013. The IBC brought about a paradigm shift from the existing debtor in possession to a creditor in control regime. So what does it mean? Generally, it means that in many of the cases earlier to 2016, it was the debtor who was the king. But post IBC, the creditor had an effective handle on whatever he had lent. The basic purpose of IBC was to reorganize and bring about resolution of corporate persons, partnership firms, and individuals, that is, insolvency resolution, to resolve the claims involving insolvent companies to tackle bad debt loan problem affecting the banking system. Further, the objective was to resolve insolvency in a strict time-bound manner. The evaluation and the viability of the proposal of a distressed corporate debtor must be completed within 180 days. Of course, it also provided a moratorium period of 180 days, extendable up to 270 days for a company. But for the startups and small companies, the resolution time period was 90 days, which could be extended by another 45 days. Moreover, this act also appointed a qualified insolvency professional as an intermediary to overlook the task of insolvency process for quick and speedy redressal. And also, we had what is called as the Insolvency and Bankruptcy Board, an independent regulating body for administration and governance of this particular act. So when a company or a corporate becomes an NPA, the defaulting company goes through what is called as CIRP, or what is called as the Corporate Insolvency Resolution Process, as per the IBC, that is the Insolvency Bankruptcy Code. While all effort is made to revive the company, if it fails, it goes into liquidation. Now, broadly, there are three stakeholders of it in a defaulting company. You have financial creditors, that is, those who lend money to the company. You have operational creditors, those who provide goods and services in the normal course of business. And then you have the corporate debtor, that is the company itself. Having given you a very brief thing about IBC, let's see how IBC has functioned during the last 7 years of its existence. So here are some numbers that I'm going to throw out, and it'll be easy for us to judge whether this particular act has been successful or not. Now, since its inception in 2016 till December 2023, 891 cases were resolved, leading to a direct recovery of rupees 3.21 lakh crores, or about 32% of the creditor's admitted claim. In the first 5 years only, 500 resolutions happened. In 2022, it was about 180 cases, and in 2023, it was likely to be around 300 resolutions. 27,514 insolvency cases covering defaults of rupees 9.74 lakh crore were withdrawn or settled by October 2023 before the NCLT's admission. Now, NCLT stands for National Company Law Tribunal, the adjudicating body under the IBC. 68% of the ongoing insolvency cases as on 2023 had exceeded the time limit of 270 days, which the IBC time frame provides. And as at the end of December 2023, there were 2,476 cases involving a debt of 1.7 lakh crores covering insolvency resolution of personal guarantors pending in NCLT and DRT. NCLT, of course, you know, it's National Company Law Tribunal. DRT stands for Debt Recovery Tribunal. Now, just for the record, these proceedings, I'm talking about the proceedings regarding the insolvency resolution of personal guarantors. It involved some very big industry bigwigs like Anil Ambani, who had given a guarantee of 1,384 crores for his company. Singhal and his wife Aarti, who had guaranteed 12,776 crores of loans given to Bhushan Steel. And Videocon's Venugopal Dutt and other promoters have guaranteed loans worth 6,157 crores. So you can imagine that only under personal guarantors, the total amount of pending insolvency proceedings were 1.7 lakh crores. So what has changed since the coming of this particular act? The first thing that happened was the regime has fostered a greater credit discipline among borrowers. Now, why am I saying that? So let's take some figures here. The IBC indirectly has contributed to the decline in bad loans in the banking system, which stood at a decadal low of 3.9% as of March 2023. Now, since the staffing in NCLT was wholly inadequate, more than 3 dozen officers have been appointed to NCLT, the adjudicating body under IBC. Now, as per banking report, IBC beat all other tools of debt recovery. Now, here are the percentages of claims which have been recovered through various other institutions or through various other routes like Lok Adalat. In Lok Adalat was able to just recover 2% of the total claims. DRT, that is the Debt Recovery Tribunal, was able to recover just 9.2%. Recovery under Surfasi Act was just 27.6%. But under IBC, it was 40.3%. That's a fairly huge jump. Now, Supreme Court recently allowed the banks to enforce personal guarantees, and this is likely to bring about a sea change in the bad loan ecosystem in the banking sector. Now, as per data provided by IBBI, the Insolvency Bankruptcy Board of India, where a corporate went into liquidation. The liquidation value was just 7.1% of the claim, a measly amount to gain, which is to be distributed between financial creditors, operational creditors, and corporate debtors. Now, in case of a corporate resolution, the figure gets pretty interesting. The realization was 175.9% of the liquidation value, whereas the realization in terms of percentage was around 30.4% of the total claims, clearly showing that there were advantages in corporate resolution. A record number of 273 firms were rescued through insolvency law in 2023. The resolution fetched the creditors more than three times the amount, around 67,000 crores, as against 20,260 crore through 160 such debt resolutions in 2022. From March 2022 till December 2023, a total of 2,166 IBC cases were admitted, and out of which 2,143 cases have been closed. So that itself shows you that IBC has been of a great deal of success as compared to the earlier years. Now, what we need to change, or what needs to change to make it much more effective, and to see that we are able to effectively deploy whatever assets are lying in the defaulting company's kitty. So, for one thing, what we could do is, for currently, if you see the MSMEs, there is an enabling provision for them for a compact and largely informal bankruptcy settlement process for a faster resolution under the overarching Insolvency and Bankruptcy Code. Now, this provision could be extended to the regular corporate sector and be made applicable to all the defaulting corporates. Secondly, currently, the IBC system cannot handle more than 300 to 350 cases a year. It needs to be geared to handle at least 1,000 cases a year, and more so now, since we are witnessing a broader economic momentum, which means that there's going to be more and more cases in future. There was an expert committee which was set up under the former Legal Affairs Secretary, which emphasized mediation even at the pre-default stage, and also when the insolvency proceedings have already been applied. But this would mean that both NCLT and the parties involved should be competent to refer the dispute for mediation. This recommendation needs to be accepted. The distribution of proceeds needs to go through even if there is a pending litigation. This is a very big hitch currently. The deadlines are often not met. The time frame proposed in the Act for resolution has always been exceeded. So there needs to be a greater discipline in adhering to this time discipline. The government has already planned an integrated platform for easy flow of information about insolvency cases. The portal is expected to join key pillars of insolvency ecosystem such as NCLT, NACLT, IBBI, that is the Insolvency Bankruptcy Board of India, information utilities, resolution professionals, Ministry of Corporate Affairs. All these pillars needs to be joined in an integrated platform, and the government has already planned it. The government needs to quickly act on this and operationalize this particular platform. In fine, IBC has been one of the foremost effective reforming tool post 2016 for swift redressal of NPAs in the banking system. A few positive tweaks to this act, and I'm sure a greater credit discipline can be inculcated into the borrowers. With this, see you in another episode. And oh, by the way, if you have liked this episode, please like, share, and subscribe this channel. Till then, ciao, bye bye, take care.